Hello, I'm Carl Barkemeyer. In this video, I'm going to discuss how to get a drug trafficking charge dismissed. I've defended hundreds of clients with drug trafficking charges over the last 16 years. I wrote the published book on how to defend drug charges in Louisiana. I also provide lectures and advice to other lawyers seeking help with their own clients' drug cases. Defending drug charges is what I know. Now let's discuss how to get a drug trafficking charge dismissed. Drug trafficking cases are drug possession cases. The formal charge you would receive for trafficking drugs in Louisiana would be possession with intent to distribute drugs. It is illegal to possess drugs without a prescription if they are considered controlled dangerous substances and listed in the Louisiana statutes. Louisiana has placed these drugs into different schedules, which are Schedule 1, 2, 3, 4, and 5, depending on how dangerous the drug has been determined to be. If you do not have a valid prescription to possess these scheduled drugs, then you would be in an illegal possession of drugs. If you have a valid prescription, obviously you can possess the scheduled drugs. You would then be in legal possession of drugs. If you give a prescribed drug to a friend, you could be charged with distribution of drugs, and your friend could get charged with illegal possession of drugs. Drug possession can be actual, joint, and/or constructive possession. These are legal terms you'll only see in the court setting. However, they are important to understand for any defenses. The defendant would be in actual possession of drugs if the drugs were on his person, which means he had the drugs in his pockets, cigarette pack, or in his hand. This is the easiest scenario for police and prosecutors to prove possession of drugs. Getting a drug possession charge dismissed when there's actual possession may be the most difficult way. For example, a defendant could argue that their brother put the drugs in his pocket when the cops pulled up, and so the defendant didn't intentionally possess the drugs on his person. Now, whether or not this defense would hold up is just up to the jury. I find most people are confused about the concept of joint possession of drugs. Joint possession means that the drugs could be possessed by more than one person. It is a theory the prosecutor tries to use to get someone or multiple people convicted. For example, let's say a car is pulled over with two people in it. There's a bag in the back seat with a pound of cocaine in it. Neither person claims the ownership to the police officer. Both are arrested. The prosecutor will likely charge both people with possession of the drugs as joint possession. It could be that they went in together to buy the cocaine, and so they both have ownership rights in the drug. Unless there are some other facts the defense could present to show one of the defendants didn't have ownership of the drugs, then it'll be hard to get the drug trafficking charge dismissed. Nevertheless, if there are present facts to show the passenger was just riding in the driver's car and didn't have any dominion and control over the drugs, then this is a good defense to getting the drug possession charge dismissed. This is a common scenario and believable. Just because someone is riding in a car with another person does not mean they possess everything in the car. If the drugs are not in the defendant's actual possession, meaning they're not on him, but the police and prosecutor still think they can prove he possessed the drugs, then the theory they use is constructive possession. In the previous example, the two people would be considered to be in constructive possession because the drugs were not actually on them. The prosecutor would be asking the jury to assume they were in possession of the drugs since they were in the car with them. One of the most important defenses I consider in defending my clients in drug trafficking cases is the possibility that the police officer violated my client's constitutional rights by conducting an illegal stop and/or search. The officer must have an articulable basis to believe that the defendant committed a traffic violation or some other crime before pulling him over. If he can't do that, then the stop is bad, and all the evidence obtained after that should be thrown out. Many times the stop is good, but the search is bad. For instance, if the cop claims he smelled burning marijuana, which would give him probable cause to search the vehicle, but really there was no sign of marijuana found, then we might have a successful fight against the search. If the search is determined to be unlawful by the judge, all the evidence obtained after the search is thrown out. There are many more defenses, both factual and legal, to drug possession cases. If I discussed them all, this video would be 3 days long. But I hope this video sheds a little light on how to defend these cases. If you or someone you know has received a drug trafficking charge in Louisiana, give me a call. I'd be happy to help.